what I'm going to do is I have a couple of things I would like to get him started to speak on.
Yeah, that's fine. That's fine.
And the two major points. And the first one is, Andrew, are our local officials hands tied by the FCC, number one? And number two, and the FCC and the Telecommunications Act. And number two, can we have a town ordinance that would stop 5G in Woodstock?
Okay, so I have to, you kind of got a couple things mixed together, so let me pull it apart.
Yeah, I'd like to ask, can I ask one more clarification question? If we do have a town ordinance, should it be a town law or a zoning law?
Usually it comes in the form of a zoning code ordinance or a zoning provision. So
Yeah, it's a
let me just
zoning
give you a
law.
little bit of background, because the fact is the majority of what you heard about the Telecommunications Act is probably false. And so I have to educate. I've been lecturing to local governments in New York for 7 years now. 1 minute quip about me. I'm a litigation attorney. I've been a litigation attorney for 27 years. I've handled over 7,000 cases in federal and state courts. I'm admitted to 9 of the 13 U.S. Circuit Courts of Appeals. I've been handling cell tower cases for about 2 decades. And there's not a cell tower issue you can think of that I haven't addressed. So let's talk about the Telecommunications Act in a nutshell, because it's very different than what you've been told. When Congress was considering adopting the Telecommunications Act back in 1996, they actually considered giving the FCC the power to control the placement of wireless facilities. And they drafted a bill to do that. At the end of the day, they did pretty much the opposite. The Telecommunications Act of 1996 consists of 2 main paragraphs. Paragraph A starts with subparagraph A that says, except as otherwise provided below, local governments have the power to regulate the placement of wireless facilities. That's it. That's the law. That's been the law for 24 years. And based upon that law, local governments, sophisticated local governments have enacted what I call smart planning provision. Wireless facilities are a necessary evil. Everybody loves their smartphone, their iPad. So a goal for a local town should not be to stop all wireless facilities. Smart planning provisions are designed to achieve 3 objectives simultaneously. First is to allow wireless carriers to saturate a municipality with coverage. But number 2, minimize the number of towers or facilities you need to provide that coverage. And number 3, to the greatest extent possible, avoid or prevent the irresponsible placement of facilities which would adversely impact residential neighborhoods and individual homes, things like that. So for 24 years, local governments who know what they're doing have done a good job at that pretty much. Now, I mentioned subparagraph A. There also is subparagraph B. Subparagraph B imposes 5 limited constraints on the power of local governments when they do regulate the placement of wireless facilities. Now, in most local jurisdictions, they adopt zoning ordinances which put in place requirements for permits for any type of wireless facility. The 3 major types of facilities are cell towers, small cells, and DOS systems, the last of which consists of multiple nodes. And basically, what a local government will do is adopt a requirement that says you want to build one, you need a permit. Most common permits would be a use permit, special use permit, conditional use permit. And of course, if you have height limitations and setback requirements, they could also need a variance or even a use variance. So the first and most important thing is to draft an ordinance which requires an applicant to get a permit. Of equal import, however, you must draft regulations to, number 1, indicate your legislative intent, the types of things that you want to prevent, which was the reason why you adopted a permit requirement in the first place. So just like any other zoning provision, you'll say, look, there's a special use permit requirement because we want to avoid undue impacts on adverse aesthetic impacts, reduction in property values, sufficient fall zones, things like that. Then you want to give your local board, whether it's the planning board or ZBA, guidance as to what types of factual determinations they have to make. So for example, if an applicant comes in and says you have to give us this because we have a gap in service, you have to let the board know they are required to make a factual determination as to whether or not an applicant has established a gap in service. Because if you don't, you may get challenged, you may ultimately lose. So we can talk about that more later. Again, I'm just trying to give you the nutshell. And third, you should give them guidance about what type of evidence they should look at. One of the things that bothers me, whether it's New York or California or Virginia, Tennessee, in 90% of the applications I've seen submitted by applicants, they knowingly submit false or material and misleading information to local boards. They submit false propagation maps, false FCC compliance reports, and as a general rule, the local board has no idea that the documents that are in front of them are totally false or bogus. And I've even seen it where they deceive a local board. They walk out and they laugh at how gullible the local board was. So you have to give your local boards guidance as to understand what they're looking at and how to process it. If you do this, you have the power to control the placement of wireless facilities. You can deny applications, so long as you deny them for a legally permissible reason and you do it the right way. For example, one of the constraints that the Telecommunications Act imposes upon local boards is you want to turn down a facility, it has to be in a separate written decision, has to be based upon substantial evidence. You have to cite the evidence in your decision. I've seen cases where they turn down a tower because somebody wants to put a 125-foot or 150-foot tower 16 feet from someone's front door. And the applicant says, we need to put it here because we have a gap in service. And a planning board says, we turn down the permit because we think it's going to have an adverse aesthetic impact. And that's a perfectly proper grounds. But they don't make a factual determination as to whether or not the applicant proved there was a gap in service. So the applicant files a federal lawsuit, and in 90 days, get an order from a judge telling you, you have to let them build the tower. And the last thing I'm going to touch very quickly is threats of litigation are hollow. And here's why. Even if a town somehow violates the Federal Telecommunications Act, and the applicant sues you in federal court and wins, the town doesn't have to pay them a penny. The Telecommunications Act is not entitled to them to get any money damages or attorney's fees. The only thing they get is the permit. So that's my 2-minute nutshell. Now I'd like to hear from you any questions you have, because pretty much I can, go ahead. Richard, you're first.
A couple of questions.
Sure.
I believe there's a 90-day turnaround once an application is received. Is that correct?
Okay. Well, under the Telecommunications Act, as it was drafted, it says local governments must act on an application for wireless facility within a reasonable time. Back in 1999, the FCC came out with a ruling and said, okay, for new cell towers or new facilities, you have to do it within 150 days. For co-location, you have to do 90 days. The FCC has issued some more recent orders, and I think they made a turnaround for small cells and DOS systems 90 days now. Depending upon the circumstances, that can be challenged. So it depends upon, for example, if they file an application for 1,000 facilities, you can't reasonably expect it to turn it around in 90 days. There's also another important group of cases that just came out in 2020, and I'll tell you exactly what they are. In the past, and by the way, that deadline is known as the shot clock. I'm sure you've heard the term. In the past, federal courts would say, oh, a town blew the shot clock. And if you blow the shot clock and you don't make the decision within 90 days or 150 days, the applicant has a 30-day window to file a federal lawsuit. When they do, in the past, judges said, oh, the town blew the shot clock. I'm ordering you to give them the permit. In 2020, a number of decisions came down that said, wait a minute, just because a town blows the shot clock does not mean that the applicant is entitled to the permit. They're entitled to a decision. So we're going to order the board to make a decision. They don't order you to let them build a tower. They order you to make a decision. Those are brand new cases this year.
If somebody else has got a question, jump in. On the placement, for example, for say 5G small cells, okay, can our zoning law, what can we do within that placement? One is public right of way, the other is height, the other is color, the other is, those types of things. Are those legitimate to work within in terms of almost stalling or delaying or causing problems along the way? Are those legitimate?
Okay, well, yes, but in most cases that I've handled, there's two main cases, types of case I currently handle. I'm hired by individuals and groups and associations to challenge particular installations when they're bad locations. The most common grounds that I get them killed on is adverse aesthetic impacts, reduction in property values, insufficient fall zones. Those are the ones most commonly used. You can also use, of course, height limitations, setback requirements, things like that. So any legitimate planning concern can be a valid basis for turning one of these things down. Now, it is subject to a limitation, and I'll tell you what the most important limitation is. And especially with the 5G rollout, the majority, I should tell you, the majority of the 5G rollout is not being done by carriers. It's not Verizon or AT&T or Sprint. It's site developers. Site developers are companies that don't provide any personal wireless services. They make money building wireless infrastructure and then leasing space in the wireless infrastructure to the carriers. Their interests are definitely at odds with the towns, because the towns want facilities in the least intrusive locations. They want to build as many as possible. So they may come into a town where you could satisfy your need for coverage with 3 cell towers. You could put one out in the woods and one in a landfill and one in a junkyard, and that would cover the whole town. Site developers will want to do that. Instead, they want to come in and put in 120 nodes all throughout the neighborhood, every 200 feet. The reason is, once a node goes up, they get paid rent month after month after month for every single facility they install. So their interests are definitely at odds with the town. And so one of the problems with the 5G rollout is that they're installing these things. I'll tell you quite frankly, every day somebody calls me up and says, I woke up and here's a small cell 20 feet outside my daughter's bedroom window. An installation of that type will ordinarily bring down the property value and have an adverse aesthetic impact. And according to the federal courts, each one of those is a valid ground to defeat an application. So now
it's a valid ground. I'm sorry, it's a valid ground to defeat?
Yes. It can be denied upon adverse aesthetic impacts, reduction in property values, lack of sufficient fall zone. Now, there is a limitation, and that's what's called the effective prohibition. So let's talk about that. One of the 5 constraints it placed on local governments is a subparagraph in paragraph B of the TCA, which says local governments cannot prohibit or have the effect of prohibiting personal wireless services. Now, prohibiting is easy. Some towns got funny and said, look, we're going to say you can't put a cell tower in a residential district, and we're going to zone everything residential. You can't do that. The next question became, what is an effective prohibition? And so applicants would file applications that would get turned down, go to federal court and say they're prohibiting me from providing personal wireless services. So for 20 years, courts across the country have come up with a test, and here's the test. They say that a town must grant an application to build a wireless facility, even if it violates your local zoning code, if the applicant can prove 2 things. Number 1, they suffer from a significant gap in their personal wireless services. And number 2, the proposed installation is the least intrusive means of remedying that gap, and there's no possible less intrusive alternative locations. If and only if they can prove those 2 things, then you have to let them have it, okay? But the important part is to make them give you proof. Usually when it's a site developer, it's not the best location. And so local governments have to force them to give probative evidence, just like anybody else would. They'll come in with propagation maps, many of which are just bogus. Without the data behind the maps, you don't know if the propagation map is worth the paper it's written on. And the truth is, no federal court would ever take a propagation map with no verification. So let's say they come to you and say, we have a gap in service, you have to give us this tower. The first thing you should say is, okay, you got a gap in service, do a drive test and give me the drive test results. Very cheap. They take a phone, they attach a recording device, they drive through town. The recording device records the signal strengths every few milliseconds, and it will give you a precise reading for all the strengths throughout the town. That hard data will show you if there's a gap, where it is, and what its boundaries are. Then and only then can a local board, whether it's a planning board, ZBA, city council, town board, can figure out if the location they're proposing is consistent with smart planning. Because if the tower doesn't fill the gap and you approve it, they're going to come back 6 months later for another tower because the first one didn't cover the gap in the first place. And usually when the application's from a site developer, it's not the best location. It's not even necessary. If a carrier has a significant gap, they'll be the one applying for the tower or the facility. So I'm sorry to throw so much information at you, but there's a lot of information to share. So,
great.
And you should get the idea. I've dealt with this many, many, many times. So questions. What's most important to me is if you have any questions, you ask me. I want to make myself available for you today.
What about if the town is trying to come up with a way that's an alternative to the Wi-Fi and the 5G?
Well, there is a ruling from the FCC that I think withstands challenge, and that is the town can't tell them what type of technology they have to use, whether they should go with a macro tower or whatever. Some towns will hire a consultant and try to come up with smart planning and say, listen, let's figure out a plan. We know 5G is coming. Let's get someone in to figure out if we can figure out how to place 3 towers away from everybody's homes, put them out in the woods, and then try to have them built there. You know, because site developers don't want to go out in the woods. I'll give you a perfect example. I had a little town in Tennessee, and it's a little town, and all around town is woods. And the site developer could put in a tower. They could put it out in the woods where nobody could see it, or they could put it in the center of town. And they chose a location in the center of town behind a gas station with a paved parking lot behind it, right up against a residential neighborhood, so that everybody's going to see this. It was either 150 or 175. And they said, this is the only place we can put it. And it was nonsense. They could put it out in the woods and nobody would see it, but they want to go into town and put it. Why? Well, it's simple. If they go out in the woods, they have to access this once a month. So they have to clear woods, they have to put in a gravel access road. Then they have to run power and connectivity. So they have to put in utility poles, and it costs them money. If they go to the gas station right up against the residential neighborhood, it's all paved already. There's nothing to clear. The utility pole's 30 feet away. They save $10,000, $15,000. If you multiply $10,000 or $15,000 times 300,000 installations, the money gets big fast. So they'll come in and say, oh no, we can't put it in the woods because we have to put it here because the woods won't meet our coverage objectives. What does that mean? It means what they're really saying to you is we have to put it here. We can't put it there because we want to put it here. So again, sophisticated local governments, if they know what evidence to ask for, they can control, for the most part, where these things go.
But what about using fiber optics? That's one of the things that we've been looking at as an alternative, is fiber optics.
Fiber optics is a great alternative. You still have to have some transmitters and receivers, but fiber optics reduces much. But again, you can't tell them what type of technology to use.
No, but I think part of Raji's question, correct me if I'm wrong, if we were in the process of moving ahead with fiber optic, and a cell company or developer comes in and wants to do 5G small cell or something like that, would that be an argument against them?
Not necessarily. What I've seen governments do is if they're moving to fiber, sometimes they'll reach out to the carriers directly and say, listen, can we come up with a plan? So we don't have to have these all over the place. Can we go to fiber optics? And they'll be amenable to trying to work with you, the carriers, all the majors, Verizon, AT&T, Sprint, T-Mobile. If they think you want to work with them, they'll try to work with you.
So that's interesting. I didn't know that it wasn't the carriers, so I learned something new from you.
Yeah, right now the 5G rollout's very interesting. Like, for example, from my understanding, there's nobody looking to roll out 5G in Woodstock right now, but that doesn't mean applications are not coming, right? The site developers are going to areas where nobody's looking to put in 5G. They're in a race. The biggest site developers are racing against each other, and they want to get these installations in. And I know that because they go into areas and they want to put in, they go into affluent areas first, and they want to put in 50 or 100 nodes, and they claim it's a 4G. Then when I access Verizon's public database, I see that there's no gap in coverage in 4G at any of the locations where they will install it. That suggests to me they're claiming it's for 4G, but it's not. It's for 5G. And so they're getting it ahead of time. So when Verizon or whoever is now ready to roll out 5G in your area, the site developer can say, hey, I've got all the infrastructure. You can just come on, just start paying me rent, and I'll turn on the key. I'll give you the keys.
Are these huge companies, these site developers? Are there just a few of them, or?
There are some very, very big ones that have tens of
Raji,
thousands of
just so you know, our tower here was put in by a private developer. It wasn't Verizon, or it was a developer that came in. They got, what, 3, Steve? I don't know who's on our tower now. Verizon.
I don't know who's on.
I think there's 3 of them.
I don't know who's on the California Quarry Tower, but there's 24 antennas up there.
These aren't private site developers. These are companies, right?
Well, on the tower, but the tower was developed and installed and put in through a developer. That's not a Verizon tower.
Some of the big site developers in New York, some of the most active ones are companies like called Crown Castle and Extenet. I've had many applications I dealt with from both of them.
I don't know the name of ours.
Crown Castle owns all the fiber here in Woodstock.
Yeah, I've heard of them.
Yeah, Steve, I just want to jump in. I don't know if you noticed that Connor joined us.
Yes, I admitted him.
Yay! Oh, yay!
His mic is muted.
He can turn off his
I'm going to ask him to unmute. I just asked him to unmute.
Connor, unmute. Connor,
welcome to the meeting, Connor.
Yeah, Connor, we believe you're there, but we can't see you and we can't hear you. We just see your
unmute.
We just see your name is all.
I have another question for Mr. Campanelli. For Andrew. Andrew, if they want to come in, and you said they have all of these different 5G transmitters, will they have to have an application for each one, or will they have an application for the whole batch as one application?
Well, in most, and in part, it's going to depend upon your local zoning code, but in most jurisdictions, there can be applications filed for multiple facilities. Cell towers and small cells are often done one at a time. The only ones that have to be done group is DOS systems. DOS stands for a distributed antenna system. And the applications I've seen, they're typically anywhere from 8 to 25 nodes, all which work collectively as one distributed antenna system. So small cells can operate independently, macro cells or cell towers can operate independently, but they can come in and file an application for 2 cell towers or 3 small cells or 30 nodes.
But if they're 500 feet apart, you're saying we can require them to do one for each pole?
I don't know that I would do that. For a DOS system, I wouldn't do that. I don't know really of any local zoning ordinance that limits an application to a single installation. But each one has to be analyzed on its own merits. Okay. Subparagraph A of the Telecommunications Act preserved to local governments the power to control the placement of wireless facilities. So you need to have your local zoning ordinance drafted in a way that it vests your boards with the maximum power to control the placement of wireless facilities. So the first thing you want to start out with is permit requirements, basically. And in those permit requirements, you want to say, you want to build a cell tower, a small cell, a DOS system, you have to get a permit and set standards. Now, along with the permit requirements, you should codify the legislative intent. Okay, and what that is if someone says you need a special permit to build a cell tower, sophisticated local governments will start out by describing the types of potential adverse impacts which precipitated the town enacting the permit requirement in the first place. You want to say, we want to ensure that wireless facilities are placed in a way that they don't unnecessarily cause adverse impacts on aesthetic impacts, reduction in property values, insufficient fall zones for structural failures, fires, ice fall, debris fall, so on and so on. So that someone can argue whether or not an application would not only meet the requirements of your code, but would inflict upon nearby properties the precise types of adverse impacts your code was adopted to prevent. So that's number one. Then, of course, you identify the board that makes decisions on the permits. So let's say it's special use permit. Usually that's going to go before a planning board. You must give them guidance, okay? You must tell the planning board what types of factual determinations they're supposed to make. So, for example, if someone says it's going to have an adverse aesthetic impact on my home, they have to make a factual determination as to whether or not they believe there will be an adverse aesthetic impact on the properties and what they're basing their decision on. Could be on testimony, could be on letters, whatever. They have to determine whether or not it's going to reduce property values if somebody claimed that's the case. They also should determine if an applicant comes in and says, you have to let us have this because we have a gap in service and there's no potential alternative, less intrusive location. Your board must make that determination, whether the applicant has proven it or not, because if you deny an application because of aesthetics, and an applicant has said, we have a significant gap, and you don't find whether or not they showed there was a gap, you lose by default. Mm-hmm. Under the federal law, any denial of a cell tower must be based upon substantial evidence in writing. So you want to say, we find we're going to turn it down because it's going to have an adverse impact on property values, and the evidence we have is this property owner brought in a letter from a professional, whether it's a real estate broker or an appraisal, saying it's going to reduce the value of your house by 30%. The next thing you have to do is give your board some guidance as to what type of evidence they should ask for, so they can understand if they see a false document. I'll give an example, an FCC compliance report. They always give you an FCC compliance report. When they hand it to an average board member in a small town, it might as well be in Latin. They have no idea what they're looking at, okay? So you gotta give them some guidance. The two most common types of frauds that I've seen perpetrated through false compliance reports is claims of compliance with the wrong standard or the distance game. I'll tell you what that means. I was at a planning board, town board session in the town of Hempstead, New York. And they got their RF engineer to get up in front of the board, and a board member asked, this facility goes up, the level of radiation it's going to expose people to, will it be below or will it exceed the FCC's limits? And he said, oh, it's going to definitely be below the limits. And when I got a chance to cross-examine him, my first question was, what limits are you referring to? Because there's two different sets of limits. The relevant set of limits are the general population exposure limits. That's the level of radiation to which they can expose members of the general public. There's another set of limits that's called the occupational exposure limits. They're much higher, and they're designed for people who work on towers and made a conscious decision to expose themselves to higher levels of radiation. So if an RF engineer says, oh, it's going to be within the FCC's limits, make sure they're talking about the right limits, because I caught somebody doing that, and I got him to admit that if the facility went up, it wouldn't be within the FCC's general population exposure limits, but it would have exposed members of the general public to radiation levels which exceeded those limits by 400 to 600%.
Wow.
The other trick they play is what's called the distance game. And here's what that is. When they give you an FCC compliance report, they have to calculate the level of radiation they'll expose people to. The reason is the facility doesn't exist yet. The easiest way to prevent a false calculation is with a false distance factor. The first factor they start with in any calculation is they have to start with the factor of how close someone can get to the tower or facility. The closer someone gets to a facility, the greater the level of radiation they get exposed to. To prepare a false FCC compliance report, which shows the level of radiation is going to be a fraction of what it actually will be, all they have to do is start with a false distance factor. So for example, I had a case where they wanted to put antennas in a church steeple. And they said the closest that anybody can get to the church, to the transmitter, is going to be 60 or 80 feet from the top of the church steeple down to the sidewalk in front of the church. That was false, and they knew it was false, because the church steeple had a clock which has to be wound every 8 days. And because it was a historic church, there were tours throughout the steeple. And so the closest anybody was going to get to it was 2 feet. And so the FCC compliance was false, and they knew it. But they did it anyway. Now, your board, if they don't know how to read it, they wouldn't recognize it. The same goes for false propagation maps, false visual impact analysis. You have to give them guidance as to how to analyze what's given to them. Because again, in my experience, in 90% of the applications I've seen, the applicant has submitted false and misleading information. And it's not by mistake. But even if the facility is going to be FCC compliant at the time they build it, what about at all times after that? The truth is, these facilities are actually completely unregulated. And here's what I mean. The vast majority of facilities for the 5G rollout are below 200 feet in height. And because of that, the FCC has no idea where they are and no idea what level of radiation they're exposing people to. First, because no facility under 200 feet in height has to be registered with the FCC. Now, the FCC set these general population exposure limits for radiation. However, unless somebody actually calls them up and says, I tested a facility, and this facility at this corner of this block is emitting radiation levels which exceed your limits, unless somebody makes that phone call, the FCC never, ever tests the radiation emanating from these facilities, and the wireless industry knows it. So we've had private testing done, and we found many facilities exceeding the FCC's limits. Now, knowing that, local governments are the first and only line of defense against their constituents being exposed to excessive levels of radiation. I mean, illegally excessive. And so some local governments have been enacting testing requirements, and there are what I describe as 3 levels of testing requirements. The first is the self-paid testing. Basically, local governments enact an ordinance that says, we are going to randomly test facilities in our jurisdiction. The town's going to pay for it, and without telling the owner when, we're going to have an RF engineer test it. And if we find the facility exceeding the FCC's limits, we're going to schedule a hearing and give the owner 30 days to tell us why we should rip down the facility and strip them of their permit. That's level 1. Level 2 is the same thing, except they make the owners of the facility pay for the testing. And some towns in California started that about 8 years ago. And level 3 are the key TAM provisions, which I helped the city of Calabasas do it in California. The key TAM provision deputizes every citizen. Basically what it says is at any time, any citizen can test a wireless facility. And if they find with an engineer that the facility is exceeding the FCC's limits, they can personally bring a lawsuit against the owner of the facility. And if they prove that it was exceeding the FCC's limits, the owner of the facility has to pay their attorney's fees. So every time a town adopts something like this, the wireless industry threatens them. But remember, if you get sued by the wireless industry, and even if they win, they don't get damages and they don't get attorney's fees. At worst, the court would say, well, your law is no good for whatever reason. But if you don't do any of these things, nobody is regulating these facilities. Nobody's testing them.
I want to ask you a question, Andrew. 2 questions, actually. First of all, have you helped municipalities draft ordinances that did stop 5G?
Thanks for asking that, Steve. That's a great. I was going to ask that same question.
Right.
Thank you.
Wanted to ask that.
Well, There's a difference between stopping 5G and being able to control the placement of wireless facilities. If 5G is not necessary, then you can stop it. For example, if a site developer comes in and wants to put in 5G installations, but no carrier has coverage there, theoretically, you can just tell them no. You haven't established a need for this facility. But the truth is, because 5G has to be so close to people's homes, you can still deny them based upon adverse aesthetic impacts, reduction in property values, things like that. Now, you're probably going to hear someone say, oh no, you're preempted, your hands are tied. And I hear that all the time. There is a new FCC interpretive order. When I say new, it's from September 16, 2018, which I think is ineffective. And I'll tell you exactly what I mean. Remember I told you earlier, federal courts for 20 years have interpreted the language in the FCC, in the Telecommunications Act, that says when an effective prohibition occurs. These cases have gone up to the U.S. Courts of Appeals for the Second Circuit and all the other circuits. Federal judges are bound by these tests. So if someone wants to claim, you must give me approval, even if it violates your code, but because saying no would be an effective prohibition, and you say no, they would have to file a lawsuit in federal court, and the federal judges are bound by the circuit court rulings, which say an effective prohibition occurs when they prove there's a significant gap and the proposed installation is least intrusive means. They can't meet that test for the 5G rollout. So the wireless industry went to the FCC and got them to issue a new interpretive order. And here's what they say. They say after 24 years, we, the FCC, interpret that effective prohibition language, meaning that applicants don't have to prove there's a significant gap in service, and they don't have to prove, contrary to 20 years worth of federal court decisions, they don't have to prove that their installation is the least intrusive means of remedying that gap. All they have to say is they need this facility at the location they want, at the height they want, to either improve an existing service or to add a new service. I don't think that has any effect on a town's ability, because I don't think the FCC, number one, can take away the powers preserved to towns by Congress, wasn't intended. They can't wipe out 20 years of federal judges' interpretation, and they can't strip local governments of 20 years of local zoning regulation. So the wireless industry is going from town to town, showing this as gospel. And the closest thing I have to a decision on so far was one federal judge in New York that said, and I'll quote him, "It's not up to the FCC to put words in the Telecommunications Act that aren't there." So that's why I think I'm right. I think local towns still have the power to control the placement. I know they have the power to control wireless facilities, but to the extent an applicant says, you have to give it to us because this new interpretive ruling, I don't think it has any effect on the ability of towns to control. I think the law is fairly clear. We can't tell them what type of technology to use. So for example, if a company comes in and says, I want to use DOS systems, you can't say, no, you have to use a macro cell. As long as that, the carrier that's cited, again, because most of the applications are not even carriers. So when a company like Crown Castle comes in, they'll say, they don't say they need it for their service because they don't provide any service, at least not that I'm aware of. They say they need it for a gap in Verizon service.
Yeah.
If Verizon has coverage, maybe it's not on the band they want, but if they have coverage, arguably they can't prove there's a significant gap in their coverage. They could actually file an action under the False Claims Act, and they would bring a lawsuit on behalf of the federal government to get that money back. And if the federal government recovered that money, they'd be entitled to a reward of between 15 and 30% of what the government recovers.
How would you have standing in something like that, Andrew?
There's a federal False Claims Act, and basically what it says is anybody who has personal knowledge of a fraud committed against the government, they bring an action on behalf of the government to recover 3 times the amount of money that's been defrauded by the government. And if you do, and the government recovers money, the person who files is called a relator, and a relator gets to keep between 15 and 30% of the money's recovered.
When this first came out, there was sort of an outcry about usurping home rule.
Yeah.
Has anybody brought a case along those lines?
No, and as far as the Federal Telecommunications Act is, Congress specifically preserved, it's entitled general authority, and it preserves the power to local governments to control these things. The wireless industry has been trying to change that, but they couldn't. The scariest part right now is they're going directly to the state legislatures, and they're getting the states to adopt state laws to strip local governments of the power to control these things. They did try in New York, and I'm very pleased to report, I think it was the New York State Association of Towns that stopped it. Doesn't mean they're going to give up.
It was,
So
yeah.
far, I think they've succeeded in at least 20 states. Now, it makes no sense, okay? The bottom line is local governments are in a best position to know and understand how to prevent the irresponsible placement of wireless facilities. They know their community, they know their historic districts, they know their topography. They're clearly in the best position to protect their local community. There is absolutely no reason why a state should strip them of that power unless, and I keep saying this, and I'm going to tick off some state legislators, but the only reason a state legislator would do it would be incompetence and ignorance, and worst possible case scenario, I hope it doesn't happen, corruption. But there's just no reason for a state to take that power away from local government. Anybody can file an application at any time for a wireless facility. And then it's up to the local board, whatever type of application and required permit you have in your code. You know, many local codes have hierarchies. If someone wants to put a residential district, it's the least favorable. You have most favorable out in the woods, a landfill, a commercial district, industrial district. And if somebody wants to put a residential area, they have to show that they can't put it in one of the less intrusive locations, okay? Anybody can file an application to build a wireless facility.
Right.
The significant gap pertains to the prohibition of service language in the Telecommunications Act. Because what that limitation says is, if somebody comes in and wants to build a tower, even if it violates every provision of your local zoning code, the height limitation, zoning, district, everything, a local government must grant the application if turning down the application would effectively prohibit them from providing personal wireless services. And for an applicant to be able to use that argument and win, it is their burden to show two things. Number one, they suffer from a significant gap in the personal wireless services. And number two, the proposed installation is the least intrusive means of having that gap, and there's no potential alternative less intrusive locations. If and only if they can prove both of those things, can they then force you to let them build it. Now, who gets to determine if they proved it? That's the key. If you decide your board is going to make those determinations, you have the power to make them. So you get to decide if this applicant has proven that they have a significant gap in personal wireless services. And if you make that determination, and in your written determination, you cite the evidence based upon which you made that decision, and then they go to federal court, a federal judge is loath to overturn your factual determination. Federal judges do not want to be zoning boards of appeals, and under the law, they're supposed to give you deference. The most common mistake is when they don't make the factual determinations because they don't realize they're supposed to. Right now, all day long, I do local ordinance reviews. I do a comprehensive review. And right now, I would say 2/3 of the cases, it's individuals and groups hiring me, but 1/3 of the cases, it's the municipalities hiring me. And what they say is, give me a local ordinance review. I do a thorough analysis, and I tell them exactly what they need to add to their local code to vest them with the maximum power to control the placement of wireless facilities. And then at the same time, I also give them guidance, language to put in their code to guide their boards to make sure when they make a decision, it sticks, meaning nobody can challenge it because they comply with all of the requirements of the Telecommunications Act of 1996. So I basically I tell them exactly what's missing in their code. I give them the language they need to add. And once they add it.
I was just going to ask what his fee was. I was going to ask what his fee was. Quick question.
That's what I was going to ask, Laura.
I charge a one-time flat fee of $8,500. I mean, it takes me a good 20, 22 hours. Usually, if there's a comprehensive plan, I want to see a comprehensive plan. I want to look at your code. I read your code cover to cover. And I don't have a standard one. When I make these provisions, again, I want to make them as bulletproof as possible, meaning nobody can challenge them. So I have to draft these code provisions to merge seamlessly with your existing zoning code. So there's no one boilerplate. These are hand drafted on each code. In the 5G rollout, they're going to file applications for multiple facilities at once, number one. Number two, getting back to your suggestion that maybe the town put in the fiber optics. It's a great idea because if you put it in, you can then offer space on the fiber optics to the carriers. And that's great for them. What you're up against is a race because you'd be racing against the site developers. The site developers don't want that. They want to put in small cells and DOS nodes, which go up much faster and much more cheaply. Yes. So you end up with a worse infrastructure because they want it. Just like instead of going into a town and putting in 3 cell towers where nobody can see them because they're completely away from homes, they rather go in the neighborhoods and put them in front of everybody's house. But the problem there is, again, it's faster and cheaper for them to go just above ground with small cells and DOS nodes. And that's why there's just thousands and thousands of them going up across the whole country right now as we speak.
You can go above ground with fiber. Fiber.
No, I know.
Yeah. So, you know, but our whole, I mean, the whole point of this conference we're having right now is we want to restrict them with 5G. We already have service here in Woodstock, and we don't want any more radiation in our community. We want to protect the community from exposure. So anything that we can do to restrict them and stay within the confines of the FCC and the Telecommunications Act, you can do, right?
I don't know that you can absolutely stop 5G per se, but right now you could probably stop the installation of 5G facilities because no carrier, to my knowledge, is trying to put the coverage in your area. Right now, they're going to the most dense areas. So they're going to the cities and stuff. I don't believe, I'm not aware of any carrier right now trying to install 5G. And the key to that is making them provide probative evidence to support a zoning application. You know, there are two types of needs which require the installation of a new facility. I talked about significant gap and how you prove that. The other type of need is a capacity deficiency, where they have coverage, but the system is overloaded, so they have dropped calls. And they'll come in with some letter claiming they have a capacity deficiency, but without hard data, you have no way of knowing if they do. So it's very easy. If they claim they have a capacity deficiency, any carrier can go onto their computer, punch in some keys, and give you a list of all the drop calls for any point in time for any geographic location. So any board should demand they give you hard data, probative evidence. They should be treated like every other zoning applicant. You claim something, give us the proof. Well, I don't know, but a gap in service is pretty clear. It's been defined by federal courts, and it has to be a significant gap. So basically, a gap is an area where you're unable to initiate, maintain. When you're talking about density, you're talking about a capacity issue, not a gap. Okay?
Exactly.
And if they exceed their capacity, they're going to have drop calls, and it's super, super easy, and it costs them nothing to show you when they have a capacity problem because they have drop calls. So you can say, look, in the center of town, we have all these tourists and we're over capacity. And you know you're over capacity when you have drop calls. And with a few keystrokes, they can give you a report saying on July 23rd, 2020, at this street, between 9 a.m. and 9 p.m., we dropped 2,000 calls out of 3,000 calls. You clearly have a capacity. There are license agreements where municipalities enter agreements with carriers to allow them to go in one fell swoop and put on facilities on all their poles. And they pay rent, nominal, might be $250 a pole per month or something like that. That's what the master license agreements are. To put wireless facilities on town-owned property and even public utility property like utility poles, depending upon who owns them. So I don't know who told you that's to restrict 5G. And as far as insurance, there is no insurance they can get. There's no insurance company that will insure for adverse health impacts from wireless facilities.
Exactly, exactly. So that's my point as a strategy is if we did demand, I mean, I think it should be a constitutional right that if you're going to bring something in that is an untested technology, then you can't prove it's safe because it's untested. They've admitted it's untested, and therefore you need insurance. And so if you can't get insurance, which they can't, that kind of restricts them from bringing in that technology.
Unfortunately, that's something that's going to have to get resolved through litigation. That's all there is. There's no way around it. And no town is looking, no town's got extra money to throw around to look for litigation.
Right.
You know, regular TCA litigation is the least expensive litigation there is. Again, when someone brings a lawsuit, you turn down an application, they say, you violated the act, we're going to sue you. Under federal law, Telecommunications Act cases have to be expedited, which means they get resolved in a matter of months, not a matter of years. And since you don't pay damages, you don't pay attorney's fees, the only thing you pay is your own attorney's fees. And as long as the town doesn't hire a firm that decides one of its goals is to maximize its billing from the town, they're the cheapest federal lawsuits I know of. They cost very little. It's about some developers' attorneys got creative and they tried to bring an action under the Civil Rights Act, which is 42 U.S.C. 1983, claiming their rights were violated. Because under 42 U.S.C. 1983, if you prevail, you statutorily get attorney's fees under 1988. And federal courts across the entire United States have said no. I'm on the forefront of this. I mean, I'm a litigator. I go to court all day long. I've been in federal courts all across the country. I've literally handled something in the neighborhood of 7,000 cases. So the type of stuff I know you can't learn in books. You have to be there and see the false applications and all that stuff. And
Right.
and I know when I can't win a case because, you know, I'm going to end up sitting in a judge's chambers in some federal courthouse somewhere and be able to straight face say to a judge, this is the position, judge.
Sure.
So I can't go into the judge and say, judge of the town just wants to stop 5G. I know that's not going to hold water. Okay?
Right. Right.
So that's no good. Now, Steve does have my contact information. I must tell you that yesterday I did a seminar for the town of Ithaca, and the town invited local zoning authorities from across the state. And while I was doing it, apparently my website came under attack. Bots launched 8,500 attacks on my website. So my website's been down all day. So if you can't find my website, that's probably why. I have my team working on it, but apparently somebody doesn't like the information I'm giving.
Well, there you go. Yeah, the telecommunications industry probably has some experts on how to get in your way, right?
Yeah, so that's the first time my website has been taken down. So
I
this week I've had discussions with at least 18 different municipalities about updating their codes. So I can't, and that's in addition to 40 or 45 people who are complaining that a facility is going to go in front of their home. I probably had 20 or 25 people who are claiming that they wanted to demand a reasonable accommodation on the Americans with Disabilities Act because they are EMS sensitive and a facility is going to go close to their home and affect them. So, you know, on average, they'll get 100, 130 emails. So it's a little dizzying pace. The good news, I'm not alone. I have several associates. And we keep pace.
Will you be able to stop it with the ADA Act?
Thus far, when I've raised, what I've done is in the context of local zoning cases, very often someone will come forward and say, they want to put this wireless facility close to my home and I'm EMS sensitive. And what I do is if I think that it merits it, I will raise a challenge within the confines of the zoning application. So I'll go before a planning board and say that both the local planning board and the applicant who claims to be a public utility must make a reasonable accommodation to my client who is EMS sensitive under both the Americans with Disabilities Act and the FHAA. And it's accompanied by a professional opinion from the person's personal physician saying that it will adversely impact them. And thus far, I never got to court. Every single time they abandon it. I'll give you a perfect example. I had this 14-year-old girl on Long Island, of all places, who has no immune system. And they wanted to put a small cell basically 30 feet from her bedroom window. And so I went before the village zoning board, planning board of appeals, submitted a brief and said, you must make a reasonable accommodation and abstain from putting it here. And it was accompanied by a letter from her doctor who said, I'm her personal physician. I've treated her since she's 5. She has no immune system. And if you put this facility 30 feet from her basement window, you'll endanger her life, in my professional opinion. Not surprisingly, the application was abandoned. I never had to. I've been lecturing to local governments for about 8 years. The most recent one, I gave a lecture to the New York State Association of Towns training session at the Marriott Marquis in Times Square, February 20th or February 18th. And I had about, 200 representatives of local governments doing exactly this. I've been doing it for free for years, and they've been begging me to help me rewrite their ordinances. And for the first 15 years, I said no. And then I finally said, you know what? Yeah, they need help because they don't know how to do this through no fault of their own. I mean, who the hell is going to read the Telecommunications Act for 10 hours? They're not going to. And how am I going to teach them how to recognize when somebody's submitting a bogus, false FCC compliance report? So now I'm like, now I have to help them. Because these site developers, they not only deliberately deceive local governments, they laugh at how gullible they were and they walk out. And then they threaten litigation. And, some little town in Tennessee says, oh my God, they're going to bankrupt us. And I have to say, no, they're not. Even if you get sued, you're not going to get bankrupt. Zero monetary damages and no attorney's fees. The only thing you would pay are your own attorney's fees, which should be minimal. And the reason is, here's how it works. They file a federal lawsuit. Within less than a week, they get a conference with a federal judge. Federal judge calls into chamber and say, what's this about? And then the judge can we work something out? Can you find a less intrusive location? Can you make the tower shorter? And if they can't agree, the judge schedules motions. The applicant files a motion for summary judgment. The town files a cross motion to dismiss. The federal judge is very simple. They get the record. The judge looks at the decision made by the town board, whether it's the planning board or ZBA. The judge looks at the evidence that the board had before it at the time it made its decision and decides if they violated the TCA because their decision wasn't supported by the evidence that was in the record at the time they made it. The whole thing takes a few months and you're done. That's it. It doesn't cost hundreds of thousands of dollars and there's no reason for it to. Now, some firms are like, hey, I represent a municipality. Let's bill them as much as we can. As long as you don't get a firm like that, it's usually the cost is nominal. compared to every other federal lawsuit I've handled in 20
We're
years.
saying, could the town, the local municipality, put in their zoning law some reference to the ADA that the tower has to be ADA compliant?
Well, this is an interesting issue that I'm going to be litigating. Right now, I have a few plaintiffs in California that I haven't filed for yet. And here's what really is an interesting question. What if someone says that they have an EMS sensitivity? In my mind, they're clearly disabled within the ADA, within the meaning of the ADA, and they're handicapped within the meaning of the FHAA. And under both of those federal laws, you as a local government, you're required to consider their health. So
Right.
when somebody raises a challenge of that type, it literally pits two federal laws against each other. I love the case. I can't wait to bring that to federal court.
Wow.
So, I mean, you could put it in your law, but that's the type of thing that I typically don't recommend. I don't look for a town to pick a fight with the wireless industry, okay? Because towns don't have money to throw away. Some things you can adopt carry some risk. If you adopt a testing requirement, you say, we're going to randomly test facilities once a year. We're going to send an RF engineer out, and they may charge $400. It's a nominal expense. I'm going to test to see if the facility is exceeding the FCC's limits. You might get some saber rattling from the wireless industry. They're probably not going to sue. On the other hand, if you put in the code that the owner of the facility has to test them, they may actually sue. So I tell the board flat out, if you put this testing requirement in, they may bring a lawsuit against you. Okay? I want to tell you in advance what bears the risk or creates the risk of litigation. So every town makes their own decision, goes in with their eyes open. But most of the stuff, I will say, this is recommended and this is optional. When I recommend what they put in their code, recommended means it's safe. Put it in, and all it's going to do is give you more power to control where things go. I'm not saying you're going to turn down every facility. What I'm saying is by adding these provisions, it gives you the maximum power to control where they go. You get to decide where they go as opposed to the site developers. I'm a practical person. If there's a practical way out without a battle and it doesn't cost the town money, great.
Well, thank you very much, Andrew.
All right. I'm glad. I hope you guys, I didn't put you guys to sleep too much.
No,
No.
no,
I'm
no.
most concerned when a town gets sued and they hire someone, not because they're knowledgeable in the field, but because they know somebody, they're friends with the supervisor or mayor, and they really don't do a good job on the case.
Right.
You know, you can't exactly spend an hour worth of research and become an expert on the Telecommunications Act. It's frightening when I see some of the stuff out there. So, and but most of my cases have been successful. When people hire me to go before a planning board or a zoning board to stop a facility, and I take their case, because there's many cases I don't take, but to the extent I think it's a winnable case and it's an irresponsible placement, I typically prevail 75 to 80% of the time. So I don't guarantee I win every time, but my percentage is pretty good. And again, as far as advising local governments, I don't pull this out of thin air. This is based upon my experience in the federal court decisions. I know what they're looking for. You know, like I've seen federal judges say, well, the town made a decision, but the town code doesn't provide guidance to the planning board as to what type of evidence they should consider. So the federal judges are spoon feeding us, telling us what to put in the code. And if you put in the code, if they have 3 towns to go into and 2 towns have very bare bones zoning ordinances, and the 3rd town has a comprehensive ordinance, which requires a lot more information, guess where they go first? They take the path of least resistance. And that's just consistent across the country. I don't care if it's Tennessee, Virginia, Oklahoma, wherever it is, it's consistent. They want to build as many as they can, as fast as they can, where they encourage the least resistance. They draft them for the specific purpose of vesting the local government with the maximum powers that Congress intended to preserve to them. This, unfortunately, right now with the 5G rollout, I'm pretty much working 7 days a week. And these types of things, I do blocks. So I'll come here on a Sunday and spend 11 hours in a block because I can't really concentrate if I'm taking phone calls and emails all day. So the phones aren't as bad on Saturday and Sunday, or I'll come and put 7 hours in at night. And sometimes the town tells me, look, we know they're coming in. Could you please jump on this? And so to the extent I can, I'll put everything else aside and I'll spend all Saturday and all Sunday. And then if I have a trial, I mean, I have, with the pandemic, fortunately, all of my trials have been put off because the court's been closed. But if I get a 3-week trial, I'm out of commission.
I wonder, Mr. Andrew, if you could tell us a little bit about Title I and Title II, how with Title I, there's no preemption, and with Title II, there is. You know about that?
No, I'm not sure what you're referring to. I have the Mozilla decision. It's like 60 pages. It would take me an hour and a half to go through that. So I'm not going to go through that. If you have a specific question, just email it to me and I'll respond. But Mozilla is a lot to talk about. There are so many lawsuits going on over this right now. Again, I could have a 2-hour discussion just on the Mozilla case.
Okay.
I don't think it'd be constructive, but again, I'd be happy to talk to you later about it, but
yeah,
I'd put you to sleep at this point.
Okay.
Yeah.
All right. Well, you know what? I think that's pretty good. We're real happy. I'm real happy with the conference, and I thank you so much for taking time to be with us.
My pleasure.
And I'll call your office tomorrow.
Okay. All right.
Yep.
I'll be in.
Thanks everybody. Thanks
Thank
again,
you so
Steve,
much.
for setting this up. Thank you, Andrew, very much,
The
and thanks
pleasure
everybody.
speaking. Thank you.
attending.
Pleasure to speak with all of you. Good night.
Yeah.
Good night now.
Take
Good
care.
night.
Night.
Night.